I'm not a lawyer, but Durk's defense team, who is headed up by Drew Finling, just filed a motion that could, if the court agrees, could drastically change this case. And I just read through it, so let me give you the recap. So the motion that was just filed is asking for 5 things specifically. Number 1, remove every judge in the Central District of California from this case. Number 2, disqualify the entire U.S. Attorney's Office that's prosecuting Durk for this case. Number 3, completely dismiss the indictment. Number 4, vacate or cancel all scheduling orders. And number 5, reopen Durk's bail and pretrial hearings. And the reason for all of this is because of death threats. According to the motion, back in February of 2025, Magistrate Judge Patricia Donahue, who is the judge that handled Durk's bond hearing, received 4 violent voicemails threatening her and courthouse staff. If this is sounding familiar, we heard about some of these threats in another motion. The caller referenced Durk by name and demanded the judge, quote, do the right thing and free Durk and his co-defendant. After those threats were made, the FBI opened an investigation, the U.S. Marshals were notified, and the entire courthouse was informed of the threats. The only people not informed of the threats were the defense and the defendants. Yet, while all of this is happening and everybody knows, except the defense and the defendants, Judge Donahue was overseeing Durk's request for bond and ultimately denied that request. And then a few months after those threats, the lead prosecutor got some threats. These threats happened in April, and they were also violent in nature, and they were by a different caller. The FBI opens another investigation, and again, everyone is informed except for the defense. The defense says they were not told about any of this until October 1st, 2025. While everyone knows, except for the defense, the government filed a superseding indictment. They asked for an anonymous jury, and they were holding meetings with the defense about general safety issues, yet never mentioned these threats that had been made. And so the point Durk's team is making is that the prosecutors and the judge had essentially become victims in this case, witnesses in this case, and investigators of this case, while also still being judge and prosecutor on this case, which they say is a conflict of interest under due process. And to make it very plain, Durk's team says, quote, Judge Donahue was in no position to consider whether Mr. Banks was too dangerous to be released while having been both personally threatened by someone purporting to act on Mr. Banks's behalf and having had her entire workplace physically and violently threatened by the same. And not once did she reveal this information and how it could potentially bias her and possibly lead her to believe that he is in fact dangerous. Yet she went on to deny Durk's bond twice. Durk's team goes on to say all of the parties in this case, meaning the prosecutors and the defense, have all been meeting and trial prepping and litigating different issues, yet the prosecutors are doing so under this cloud of having been threatened. And to be clear, the argument Durk's team is making, it's not just about the threats, it's about the failure to disclose the threats to the defense that makes this whole thing a violation of Durk's rights. They say he has a right to a fair and impartial judge, a conflict-free prosecutor, and a trial free of actual bias and the appearance of bias. And to disclose this information so late in the game doesn't fix the issue because rulings and decisions have already been made under this cloud of threats. So the true fix, they say, is dismiss the whole indictment or a full disqualification of the U.S. State Attorney's Office. But they say if the court doesn't want to do all that, as an alternative, they are asking for an in-camera review of all threat-related materials and communications, an evidentiary hearing to determine the scope of prosecutorial and judicial knowledge. They want all orders that were entered before the defense knew about these threats to be vacated or canceled. They want the case assigned to a judge outside of the Central District of California pending review, and they want all pretrial and bond hearings reopened. They're also asking for all proceedings on this case to be put on hold, including the January 2026 trial date, until all of this gets figured out. They conclude this motion by saying the U.S. Attorney's Office decision to conceal threats to the very judges presiding over this case and to continue litigating before them for months has infected the proceedings with an appearance and a reality of unfairness that cannot be ignored. The judiciary's legitimacy depends on public confidence that justice is not only done, but seen to be done. That confidence is shaken here. Defendants therefore respectfully urge the court to dismiss the indictment or, at the very least, disqualify the United States Attorney's Office and reassign this matter to a district untainted by the government's non-disclosure. Let me tell you what, that Drew Finling, he gonna file some motions. So that's the latest motion. I was actually working on a video for the motion that were filed a couple days ago, so that's coming in a minute. But tell me what y'all think about this. Do they have a point?